Hi, I'm Matthew from Frontline Law. In this video, I'm going to talk about how to set objectives as part of a negotiation. This is really important, especially when you're working with a lawyer, because we need to understand what objectives you have. We're negotiating on your behalf, we're representing you, so we need to do that work with a really clear understanding of what you want to achieve. In setting an objective, there are two numbers that we need to know from you. The first is what you want to achieve. Now, normally this is a monetary amount. If it's compensation, it might be in the tens of thousands of dollars, depending on the case. It could also be some non-monetary things like reinstatement if you're an employee, things like maybe an undertaking from the other party, or some other non-monetary outcome. That's the first number we need, is your ideal outcome. The second number we need is something that's sometimes called your reserve price, but really is your bottom line. It's the amount of money, or it's the terms that you're willing to walk away from if they're not achieved. It's really important for us to understand this reserve price, because if we don't achieve what you want, if it's below that reserve price, then we are going to end the negotiations and walk away. And that comes at a cost. It comes at a cost because you've foregone the opportunity to reach a negotiated agreement. That means that you're left with whatever other options there are. And the term for this in negotiation is called the best alternative to a negotiated outcome. So the best alternative to a negotiated outcome means, what are you going to do next? And in a lot of cases that involve lawyers, the next alternative is legal proceedings. So it could be, if you're an employee, the Employment Relations Authority pursuing a personal grievance and asking the authority to determine that. If it's civil litigation, it could be in the district court or the high court. Whatever it is, it's normally formal legal proceedings. And the cost of legal proceedings is a literal one in terms of the money that you'll need to spend on a lawyer, but it's also the time involved in legal proceedings, and it's also the risk of uncertainty. Because no matter how strong your case is, there's always the risk that you might not be successful. If that happens, you get nothing, and you might be liable to pay contribution to the other side's costs. As lawyers, our job is to inform you about these costs, tell you what your chances of success are, so that when you're in negotiation and you're trying to set that reserve price, you know what it's going to cost you if negotiations aren't successful. That gives you an idea of the cost, and it helps you decide what your bottom line is. Every case is different. We need to understand all the relevant facts. We need to probably look at the law really closely to understand how it applies to your situation and what the likely outcome will be if you go and pursue formal legal proceedings. So if you have an issue and you're hoping to resolve it by negotiation, that's a great start, because normally resolving it by negotiation is a good outcome for both parties. It's better than going to court. But if negotiation isn't successful, then you're often left with no other option but to go to court. So talk to a lawyer, give us a call at Frontline Law for a free initial consultation. Thanks for listening.